Welcome to the March 24th session of the Phoenix Congress, where we are writing a blueprint for a better America. This legislative package will end poverty with universal basic income, end mass incarceration with major criminal justice reform, and end the endless wars by bringing our troops home and reducing our military budget. Today's session is the 20th of 21 public hearings on the 2022 legislative package, and we will review sections 461 to 504 relative to a tax on lawyers and universal suffrage. The last session will be next Thursday, March 31st at 1:30 p.m. Eastern. For those following along at home, you can find a link to the legislative package in the description below or at bit.ly/B, lowercase drop box. If you have questions about today's sections, you can submit them in the chat. And if you'd like to offer questions or other testimony for future hearings, please use the link in the description below. Before starting, I'd like to invite you to join us in reciting the preamble to the Constitution of the United States to remind us of our duties as Americans and set the intention for what we are trying to do today. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. With that, I'd like to welcome the delegate from North Carolina's 9th District to continue his testimony on the blueprint for a better America.
Thank you, Mr. Chair. For the record, my name is Brian. I'm an organizer with the American Union and a Phoenix Congress delegate in good standing representing North Carolina's 9th District. And Section 461 is the findings and purpose for Title IV, the last subtitle, the American Union Legal Defense. And what this section does, or this subtitle does, is it goes back to our duty of establishing justice and trying to make the criminal justice system work better by ensuring more even access, more opportunity for access to legal services by everyone who's involved. In a July 2021 report, the Prison Policy Initiative, they concluded that one of the reasons mass incarceration persists is because people too poor to afford their own lawyers are denied meaningful representation in court. This injustice happens because public defense systems, the systems tasked with providing attorneys to those in need, are severely underfunded and overburdened. And so this subtitle will work to address that problem. And we've all heard our Miranda rights in TV shows and movies and things like that. You have a right to an attorney, and if you can't afford one will be provided for you. This is one of the things that America does to establish justice, thanks to a 1963 Supreme Court ruling in Gideon versus Wainwright. But according to the website, Gideon at 50, 80% of criminal defendants require court-appointed lawyers. And so what does that mean exactly? How does that help us establish justice? And the answer really is it depends a lot on where you live, what state you're in. Some states provide minimal or no state funds for public defenders. Sometimes the incentives are wrong, where a public defender will just get a flat fee per case, no matter how much effort they put into it or how much work it needs. But we can do better by providing, making sure that people have a public defender, have access to legal services earlier in the process. There was a pilot program in California, and they reported in 2020 that having a lawyer up front made it more likely that people could get good bail. And as we talked about in the section on bail reform, if you're stuck in jail while dealing with a criminal complaint, your ability to negotiate, to defend yourself goes way, way down. You're encouraged many times to take a plea bargain to a self-service conviction just to put the incident behind you and try and get out and get back to your life. So I'd like to go ahead and read the findings from section 461 into the record. The Congress finds the following. 1, members of the legal profession are trustees of the judicial system, officers of the court who serve on the front lines of establishing justice. As guardians of legal knowledge, they have a duty to the public at large, but the injustice rampant in the judicial system demonstrates that as a group, they are failing in their duty to be stewards of justice. America must do better. 2, over the last 35 years, lawyers have raised their fees at twice the rate of inflation. Rather than fully utilizing their productive capacity, they've chosen to increase their prices, correctly calculating they can earn more money with fewer but higher paying customers with an inelastic demand for their services. 3, the decision to price many Americans out of the market for legal services has fallen heaviest on the people most likely to find themselves in need of legal knowledge and representation. Those below the poverty line are 3 times as likely to be arrested, and the prevalence of cash bail also negatively impacts their available resources for a legal defense. 4, without a knowledgeable advocate to guide them, poor defendants find themselves, on average, serving a longer sentence. This has led to a 2-tiered system that makes a mockery of the phrase, with liberty and justice for all. Shakespeare famously suggested killing all the lawyers, which would even the playing field, but a preferable alternative is a fee and dividend model to address this issue. 5, this subtitle establishes a 12% excise tax on practitioners of legal services and distributes the collected fees as vouchers to anyone who is arrested. There are an estimated 1.3 million lawyers in the US, earning an average of $125,000 each year. And this puts the potential amount of voucher dollars at upwards of $15 billion annually. 6, this should have 2 effects. First, by creating a supply of voucher dollars, a new market for legal services will be created, generating business opportunities for lawyers who would otherwise like to serve the community and be stewards of justice, but are unable to generate sufficient revenue. Second, by providing prompt access to legal expertise for those who are involuntarily thrust into the legal system, justice will be promoted. 7, simple arrests can have cascading consequences. In 2015, Sandra Bland was arrested after a pretext stop, held for days when she could not afford bail, and started missing her new job. Her body was discovered in her cell on July 13th. 8, legal vouchers will not be redeemable for cash, but they will be transferable, so they could be donated to people in need of additional legal services. This will also enable incarcerated people to seek funds for professional reevaluation of their legal situations. 9, last, the program director may suggest revenue thresholds where the voucher distribution could be expanded to provide resources to parties in non-criminal cases, including family court, small claims court, and other civil proceedings, where those who cannot afford legal representation are frequently denied justice. The purpose of this section is to cultivate justice by rebalancing the economic forces in the legal profession. This is how we can make the judicial system work better, by using a fee and dividend model to make sure that resources are available to those at the bottom of the economic ladder. Next, Chair, I think that concludes my testimony for section 461, and I'd be happy to answer any questions.
Thank you. Yes, can you repeat again how the vouchers are funded?
Yes, there's a 12% tax that we'll get into in section 462. Section 462 will answer a lot of that question for you.
Fantastic. Trying to see if there's anything else. No, seeing no further questions. Section 461 is assigned to the subcommittee on findings. You may proceed. Section 462.
All right, thank you. Section 462 establishes an excise tax on providers of legal services. What it does is it adds a new chapter to the Internal Revenue Code and puts a 12% tax. Let me share my screen and go through this section together. So it creates a new chapter, chapter 51, and section 5000D is an imposition of tax on the sale of legal services. It's equal to 12% of the amount. So if you're getting free advice from a lawyer, then 12% of 0 is 0. But if lawyers are selling their services, there would be a 12% tax in general paid by the person for whom this service is performed. We define legal service as a service involving advice to others in matters of law or representing them in court, and provided by someone formally trained in the law and possessing a degree from an institution that provides such instruction. There is a variety of different types of lawyers, but this is seemed like a definition that generally covered them. We in subparagraph 4, we cover in-house counsel. So if you're a lawyer who's not actually providing an invoice for your services, billing someone directly, your in-house counsel, the compensation for such employee is the part that is considered the sale price in terms of determining the tax in subsection A. And employees of a tax exempt organization are exempt from this paragraph. So if you're a lawyer working for a nonprofit, this tax on your salary there wouldn't be a tax on your salary, because as a nonprofit, you're hopefully already serving the public good. And then subparagraph 5 for the public good clarifies that this tax shall not apply to employees of any government body or agency, or the purchases of legal services by a government body or agency. So again, if it's the government that is buying the legal services, the presumption is that they are serving the public good already by doing that, and so they would be exempt from this tax as well. And this would go into effect July 1st, 2023, and apply to services performed after that. With that, Mixed Chair, I think that concludes my section for 462, and I'd be happy to answer any questions.
Thank you. Yes. So just help me to remember, you said that, so this is how the vouchers are funded, and then everybody is given vouchers, or they're only given vouchers when they are arrested or when it's deemed that they need them?
Yes, when they're arrested, we will get into that in sections 463 and 464 on the setup of the grant program and how they're distributed.
Okay, cool. Seeing no further questions, section 462 is assigned to the subcommittee on taxation. You may proceed to section 463.
All right, thank you. Section 463 establishes the legal services trust fund. And so share my screen again. All right, and so we establish a trust fund in the Treasury of the United States that collects all the money, all the revenues that were raised from the previous section through the tax on lawyers. I just feel like it's worth mentioning that lawyers are generally one of the least trusted and most disliked members of our society, right up there with like used car salesmen and congressmen and so on and so forth. So we can harness their knowledge and redirect it for the public good by putting this tax on them, putting it in a trust fund, and then using that trust fund to pay for the legal services grant program, which we'll talk about in section 464. And that concludes my section for 463.
Thank you. Seeing no questions, section 463 is assigned to the subcommittee on taxation. You may proceed to section 464.
All right, thank you. Section 464 is how the legal services grant program is actually implemented. And so we've got a few definitions to start off with. Most are pretty self-explanatory. Activity is any changes in the amount of funds in an account. Law enforcement agency covers federal, state, and local government, anyone who is authorized to place individuals under arrest. The providers are providers of legal services, as we've defined in the previous section. The qualified individuals for this program is any person arrested within the United States after January 1st, 2024. So that's 6 months after the tax goes into effect, to give the program director time to accumulate funds and set up the voucher program. And voucher doesn't have to be any physical voucher, just it could be a card, a code, any means of access to the legal services grant program. All right, subsection B establishes the actual grant program within the Office of Justice, and an assistant attorney general will oversee it, with a director who will award these grants, carry out these grants using the funds that we just talked about. Some of the startup funds for this program come from Section 559E of Title 16, which was drug war funding that will no longer be obligated when the federal war on drugs ends. So it'll be repurposed to establish justice in this way. And the purpose, the duties of the functions of the Legal Services Grant Program is to establish a program where qualified individuals receive a grant for legal services that they can use from any participating provider. Subsection D in general sets up how this program works. The Legal Services Grant Program will preemptively establish individual accounts for legal services grants prepaid with $200. So you could imagine essentially sending out prepaid gift cards to law enforcement agencies, if not physical gift cards, the codes or the access codes and things like that, in order to access an account within the Legal Services Grant Program. And then the next thing is they'll establish standards for how law enforcement agencies should promptly distribute a voucher to any individual arrested, notify the Legal Services Grant Program of the amount, the name and birthday of the individual provided a voucher, a summary of the charges, and the number of vouchers that they have left. So we've got an ongoing accounting of how these are distributed. The Legal Services Grant Program will ensure that the amount in the account is at least $100 plus $200 for any felony charge, plus $100 for any lesser charge. So if someone is charged with just arrested for a misdemeanor, then that is the $200 that'll be pre-funded into accounts, $100 plus $100 for a lesser charge. If there are multiple misdemeanors, multiple felonies, then the amount of money put into their account would increase as needed. The next duty for this department will be establishing the voucher redemption program. They'll set minimum standards for provider participation. And in general, anybody who pays the legal tax is automatically a participating provider of legal services, but they would have the option to opt out. What this does, though, by setting minimum standards for provider participation is makes it possible for people, organizations that aren't necessarily that aren't necessarily members of the Bar Association, that aren't necessarily lawyers who have graduated from a law school and have a degree, but who it opens the opportunity for, if they're able to demonstrate minimum standards of legal knowledge and an ability to help people in these legal situations, they could be set up as a participating provider and be eligible to redeem these legal services vouchers. As they set up this program, also will make sure that there is widespread acceptance of these vouchers, and that participating providers are promptly reimbursed without fees or charges for the value used by the account holder. So if you've got your $200 voucher and you need some legal advice quickly, what are you facing? This is the opportunity for somebody who's recently arrested to be able to get a lawyer on the phone with some spending money in hand to get the answers that they need, rather than what we have now, which is maybe waiting until an arraignment or later before being assigned a public defender. Additional duties here: establishing a process for topping off the account if additional charges are filed later. Establishing a website so individuals can search by zip code for participating providers, check their account balance, and make transfers to other accounts. Establish a program where qualified individuals can transfer funds and accept a transfer of funds. The department shall ensure that this program is accessible to incarcerated individuals. Most estimates are that about 3% of incarcerated people are innocent, and there are many, many people who are stuck in prison and can't afford legal representation to get their cases reviewed. And so by opening up a process by which people can donate their vouchers for legal services to other individuals in need, will create a process by which incarcerated people can then get funds to get their cases reviewed and better seek justice. And then they'll also be responsible for, paragraph 8 here, issuing a proposed draft of legislation that, if enacted, would further clarify and implement the provisions of this section, including what additional grants should be provided for court appearances at other milestones. So whether this could supplement or how this would relate to the current public defender programs in different places. And then also establishing funding thresholds so that people who are brought into court for non-criminal cases, like family court, like small claims court, and other civil proceedings, could potentially have access to legal representation as well through this program. Also clarify that there's no cash rebates, that if the grant isn't touched for a year, if there's no account activity, then it goes back into the trust fund. And that grants are not income. They're not taxable income. And that's clarified by amending this section of the Internal Revenue Code to clarify that legal service grants aren't income. And so that sets up a framework for a fee and dividend model for legal services that will make legal services more accessible to Americans who need them and help us in our duty of establishing justice. And just with that, Mr. Chair, I think that concludes my testimony on section 464, and I'd be happy to answer any questions.
Thank you. I have a question. Is that enough money? $100, $200 for it to be economically competitive for legal services?
Yeah, it's a place to start. No, $200 is certainly not enough to represent someone all the way through a criminal proceeding, but it's about an hour of time. And one of the other things, like we said in the findings, the goal is to create a new market for legal services, so that if you are a young lawyer who doesn't have rich clients and things like that, and you would like to help to be a steward of justice, to actually, fight for the people who need legal representation, but who don't have any money. Now you've got a business model where, you can have, provide short-term advice to different clients for smaller amounts, and start building your practice that way. So once the program starts, the numbers and things can be reevaluated, but this seemed like the place to start.
Cool. And you had mentioned that current currently public defenders, a lot of the funding comes from states. How do you see the enactment of this at the federal level affecting potentially how states approach funding?
It's a great question. And there's a lot of variation right now in the way that states approach funding. Some of them do it all on the state level. Some of them do it they don't do it on the state level, and it falls to the local communities to fund their public defender programs, which means that the impoverished communities that have the greatest need for legal representation for public defenders are the ones least likely to be able to afford it. And so as a national program, hopefully we can set some minimum standards at least, and hope that sort of a rising tide lifts all boats. But no, I don't know how specific states will react to this sort of program.
Okay, thank you. Seeing no further questions, section 464 is assigned to the subcommittee on taxation. You may proceed.
All right, thank you. That concludes Title IV. And so Section 501 brings us into Title V, securing the blessings of liberty to ourselves and our posterity. And Section 501 is the findings and purpose for Subtitle A, which establishes universal suffrage. And a lot of the language in this subtitle comes from the For the People Act of 2021, HR 1. And this was the big election reform passed by the House more than a year ago. And the US Senate has done literally nothing with it except acknowledge that they received it. The House version, it included reenfranchisement of non-incarcerated Americans. So somebody who had previously been convicted and was no longer in prison would be able to participate in elections. Congresswoman Cori Bush of Missouri, she introduced an amendment to ensure incarcerated Americans could vote as well. And it did fail, but this is an issue that there's possible agreement on both ends of the spectrum. Lauren Boebert, the Congresswoman from Colorado, tweeted back in January, one citizen, one vote, end of story. And yes, that's what this subtitle does. One citizen, one vote, end of story. I'd like to just briefly read the findings into the record. The Congress finds the following. 1, Americans have a constitutional duty to secure the blessings of liberty to ourselves and our posterity. The ability to vote is the most basic conductive act of citizenship by which people can secure the blessings of liberty. 2, the United States is the only Western democracy that permits permanently excluding individuals with felony convictions from voting. Disenfranchising citizens who have been convicted of a criminal offense serves no compelling state interest and hinders rehabilitation and reintegration into society. 3, Article 1, Section 4 of the Constitution of the United States grants Congress ultimate supervisory power over federal elections, an authority which has repeatedly been upheld by the Supreme Court of the United States. The 13th, 14th, 15th, 19th, 24th, and 26th Amendments to the Constitution empower the Congress to enact measures to protect voting participation in federal elections. 4, basic constitutional principles of fairness and equal protection require an equal opportunity for all citizens of the United States to vote in federal elections. The purpose of this subtitle is to secure the blessings of liberty for ourselves and our posterity by including all citizens of the United States under the umbrella of civic responsibility. I was having a conversation with someone recently about voting. And, they said, yeah, I absolutely believe when somebody's out of prison that they've served their time and they should be able to vote. And I said, well, can I ask you, what about somebody who's still incarcerated? And they just looked at me and said, I never thought about that. Why is it that someone who's incarcerated can't vote? Where does this idea come from? And it's fairly uncommon in democratic countries. There's at least 16 of them that allow felons to vote even while they're in prison. Radical countries like Canada, Denmark, Finland, Ireland, Switzerland, the Ukraine, Spain, South Africa. This idea that people should lose their ability to vote and to participate in democracy because they're incarcerated is pretty unusual. And only the United States and only a couple other countries restrict voting rights after a person's period of incarceration has ended. So we can be a better model of democracy by going after universal suffrage, one citizen, one vote, end of story. This touches on a number of other issues in our democracy and our history, like the idea of no taxation without representation. If you're paying taxes, you ought to be able to have some say in the people who represent you. You ought to be able to vote. If you're being incarcerated, if you're being prosecuted under the laws of your state, you should have some say in the people who in deciding who writes those laws. This practice of disenfranchisement has also led to issues like prison gerrymandering, where congressional districts that have prisons in them, the people incarcerated there can be counted within that district, even though if they were able to vote, they would be represented elsewhere. And so this has the effect of, in many cases, of shifting population from urban areas into more rural areas where the prisons are located, and throwing off the balance of our representation in Congress. And there is very much an aspect of racial discrimination in this disenfranchisement. It comes from the text of the 13th Amendment. So I'd just like to the 13th Amendment and the 14th Amendment, both which allowed for punishment of a crime as a reason to treat some citizens differently than others. And as it turns out, there are two states, Vermont and Maine, which still allow the incarcerated Americans to vote. And it's worth pointing out that those are the two whitest states in the nation. All the other states put restrictions on incarcerated Americans. When it comes to people who have been released, who served their time in prison and are back participating in society, then the question becomes, at what point do we allow them to also participate in democracy? And in some states, they are restricted. And in recent years, there have been a number of stories that have come out of formerly incarcerated Americans being charged with felonies for attempting to vote. A few years ago in Texas, Crystal Mason had served 3 years for tax fraud, and a year after her release, she cast a provisional ballot in the 2016 general election, and nobody had told her that she couldn't vote. She was free walking around rebuilding her life, and regardless, she got arrested and sentenced to 5 more years in prison for casting that provisional ballot, which she's still appealing that conviction. Recently in Tennessee, Pamela Moses, who was an activist, and she was recently sentenced to more than 6 years in prison for being convicted of illegally registering to vote because she had used paperwork from her probation officer that said she was eligible. And despite the fact that the mistake had been on his part, she was found guilty. And she was quoted in the Guardian newspaper as saying, quote, "It's a scare tactic, what they did to me. It's like, if she went to jail for that, we don't need to do that. We don't need to follow her because we're going to be in jail for 6 years too." I would say it sends a confusing message to people who want to vote. Why should people be worried if they're going to be prosecuted for doing their civic duty? We can do better. One citizen, one vote, end of story. In that case, the prosecutor blamed Pamela Moses for her sentence because he gave her a chance to plead to a misdemeanor with no prison time. And because she stood up for her right and requested a jury trial, she got convicted and sentenced to 6 years in prison. Our criminal justice system is broken. And by ensuring that we can, and one of the ways to fix it is through the legislative process and the selection of representatives who will represent all the people. So the way to do that is one citizen, one vote, End of story. It's worth noting, the United States was kind of like one of the first modern democracy, and we got started in the 18th century by just letting white men of property vote, and it's better than what else was going on in the world at the time. And then the 18th century we upgraded that and said, all right, black men can vote too. And then in the 19th century, sorry, in the 20th century we upgraded that and said, okay, women can vote too. And so now that it's the 21st century, it's time to upgrade our democracy again and say everybody can vote, one citizen, one vote, end of story. That's the purpose of the subtitle. And mixed chair, that concludes my testimony for section 501. And I'd be happy to answer any questions.
Thank you. As you said, it's pretty straightforward. Seeing no questions, section 501 is assigned to the subcommittee on findings. You may proceed to section 502.
Okay, thank you. Section 502 is fairly short. It just defines two words. One is election, as any general, special, primary election, or any primary contests related to that. And it defines federal office as being the office of the president, vice president, senator, or representative in Congress of the United States. And that's all section 502 does. And that concludes my testimony on that.
Thank you. Not really a question, but you should probably add the word runoff in there too. Sometimes runoff elections happen after the general. So it would be good to specify that if we could work on that with the subcommittee.
Great, thank you. It is actually in there. I summarized a little too briefly.
Okay, cool. All right, seeing no questions, section 502 is assigned to the subcommittee on the Matthew Charles Prison Reform Act. You may proceed to section 503.
Thank you, Mixed Chair. And yes, I'll just go ahead and put 502 up here so that general, special, primary, or runoff election are all included in that. But section 503 is the meat of this section. Subsection A, all adult citizens eligible to vote. Any citizen of the United States being 18 years of age shall be eligible to vote in any election for federal office. That's it. That's the meat of the section. There's some notification requirements and restrictions on using federal prison funds if states don't notify incarcerated people that they are eligible to vote. This language comes from HR 1. Again, to make sure that we're including all citizens in our elections. And then there's subsection D, which makes all this effective January 1st, 2024, and repeals the notification programs and the restrictions on federal prison funds after the 2036 general election. So by that point, I feel very confident that everyone will be on the same page, that one citizen, one vote, end of story. Everyone gets to participate, and we won't need to keep sending out notifications at that point. So I think that concludes my testimony for section 503, and I'd be happy to answer any questions.
Seeing no questions, section 503 is assigned to the subcommittee on the Matthew Charles Prison Reform Act. You may proceed to section 504.
Okay, thank you. Section 504 is a reduction of representation. And this is a law that is already part of the United States Code, but is in need of updating. So, all right, this is section 6 of Title II United States Code. And the current law says is that if states deny or abridge the right of any male inhabitant over 21, block them from voting in elections, then according to the elections named in the 14th Amendment, then the number of representatives apportioned to the state shall be reduced. The 14th Amendment does allow for reducing participation, reducing the participation of people in elections if for participation in rebellion or other crime. And so to the extent that states have disenfranchised people based on conviction of a crime, this section of law hasn't been applied. But we update that by striking the except for participation in the rebellion or other crime. Just as a historical note, I find it interesting that it's the rebellion, that it's a very specific event that they were referring to when they wrote this law. And then of course, striking male, requirement to be male, 21, reduce that to 18 to match the 24th Amendment. I forget which one, that lowered the voting age. And so if states go ahead and restrict people's ability to vote, and they don't allow citizens to participate, then the number of representatives that they have in Congress would be reduced, that this section of law would apply, so that there would be a reduction of at least one representative, unless that would leave them with none, in which case they're exempt. But yeah, so this is the teeth of it. One citizen, one vote, end of story. Yeah, and if states don't cooperate, then they would lose representation. So with that, Mr. Chair, I'd be happy to answer any questions. That concludes my testimony on section 504.
Thank you. Just to clarify, this was just adjusting existing US code to match the language that is currently in the Constitution, correct?
Both. So yes, this is current law, but it needs a need of updated because it still refers to male inhabitants 21 years of age. And so we've expanded our voter pool since then. And then it would strike the part that permits restrictions based on participation in rebellion or other crime. So it would strike that part to achieve universal suffrage.
Okay, thank you. Seeing no further questions, section 504 is assigned to the subcommittee on the Matthew Charles Prison Reform Act. I'd like to thank the delegate for his testimony.
Thank you, Mr. Chair.
The next session of the Phoenix Congress will be held on Thursday, March 31st, so not Monday. It's a week from now, Thursday, March 31st at 1:30 p.m. Eastern. We will review sections 511 through 603 relative to taxes on pollution and the closing provisions of the Blueprint for a Better America. This hearing is adjourned.